Good afternoon and welcome to the August 2026 edition of the Divorce Support Club with me, Claire Macklin, divorce coach. And I'm joined today by Natasha Alsop from Walker Family Law. Natasha, would you like to very briefly introduce yourself just for those who have not met you before?
Yes, thanks, Claire. I am a family solicitor specialising in divorce, finance, private children, cohabitation disputes, based in our Exeter office and cover most of Devon and sometimes some of Somerset. I lead a team here of other lawyers and paralegals, and today I think we're just going to have a discussion, aren't we, Claire, about FDRs.
About
FDRs
about
today.
FDRs, exactly. And just to introduce myself very, very briefly as well, I'm a divorce coach, so I work alongside Walker Family Law, supporting clients through the emotional turmoil of separation and divorce. So, as Natasha said, today we're going to talk about FDRs. It's one of those acronyms that's bandied about, and I think what we'd really like to do today is really explain what an FDR is, what you can expect when you go to a hearing, how to prepare, all of those kinds of things. The first question is for Natasha, a really simple one, but for people watching, probably not so simple. Can you tell us what FDR even means, please?
So FDR is a financial dispute resolution hearing. It's the name of a hearing. So when you have court hearings, they all have different names extended to them. So the extra
Mm.
bit, the subtitle, if you like, and it's a financial dispute resolution. So it's a type of court hearing.
Brilliant, thank you. I mean, most of the people watching probably will not have been through this process before or through the family court system before, and it's really alien and scary. And you and I, we deal with it all the time. But for those watching, it's somewhere that most people never really want to, well, most people never want to end up. So, um, could you just talk us through what the aim is of an FDR hearing? What's the purpose?
The settlement, essentially, to try and focus everyone's minds on settlement. So that's the main aim of having it as a specific hearing, as opposed to merged with the main hearing.
Okay, so the goal is to reach settlement. So it's kind of perhaps it's part of the negotiation process. So what happens if you reach agreement um, at or during your FDR? What takes place? Could you talk us through the steps?
I can do. So it's probably, if I just give a bit of context to the
Mm,
court proceedings, so probably
yeah,
just
please
we're
do.
talking about FDR only. So when you when you're getting divorced and you can't reach an agreement about finances, or you just feel that you'd like a timetable to move it along, one party can apply to the court. So an FDR is only relevant when you're in that arena, first of all. So just to give a bit of context to anyone who might think, well, does this happen in every divorce? No, it doesn't. So if you're getting divorced, and this is all about finances today, so we're just thinking about financial matters, which is where an FDR, what it applies to. But if you're getting divorced and you think, am I going to always need this FDR? No. Sometimes you might have already reached agreement. You're just asking a solicitor to draw it up, or your solicitors might have been able to reach an agreement for you, or you might have gone to mediation and reached an agreement. And then you won't be in this process where you need an FDR. An FDR is where you've had to, in the kind of small minority of cases, really, where you think we really need the court's assistance, we can't reach an agreement ourselves. So one or both of you have decided that you need the assistance and you make an application to the court. The court then automatically says, look, we're going to list it for a hearing, which is an administrative hearing at the start. Then it gets listed for a resolution hearing. And then if you can't agree, there will be a final hearing. There can be more hearings than that, depending on the circumstances of your case. But most cases will follow that pathway. It will be the first hearing, directions, it's often called an FDA, first directions appointment, it's called different things now, but it's saying, look, what information does the court need? That's that first hearing. Sometimes that's all agreed in writing, so you don't have to go to court. The next hearing is then a dispute resolution, this FDR that we're going to talk about in more detail today. And then if we can't reach an agreement at FDR, we come on to that final. So yes, going back to the dispute resolution, if you're in that stage where you're at your FDR and you reach an agreement and you think, great, we've got an agreement now, then the court can approve that agreement on the day. Sometimes you've already got everything ready and you think, well, actually, we're almost there. So we've already drafted all the documentation. You could potentially come out of that hearing then with a final order and everything's done. So resolution hearing, you've reached settlement and you're at that hearing and you've got that final order. If you didn't expect to be in that position or it wasn't quite what you could prepare for, you may well be in a position where you're still before the court or before a judge and you can say to the court, well, actually, here's our what we call heads of agreement. Here's our the headers that the court needs to know. This is going to happen with the home, or this is going to happen with the pension, but we're not in a position yet to draft all the documentation. So what the court can then do is approve those heads of agreement. We often call it a rows and rows agreement. Approve that. Sorry, I've just got a bit beeping going on. And that will then enable the parties to then finalise it in more detail after. But that becomes a kind of binding agreement between you both, and the courts approve those heads. So the terms have actually approved at that hearing.
Okay, so that's kind of what can happen should you reach agreement, either immediately before the hearing or during the hearing. What happens if you can't reach agreement? So you come to your FDR hearing, you can't reach agreement, there's still some things outstanding between you. What happens then?
So if you haven't reached agreement at the FDR, so it's finished, so you've gone to court, you've tried everything you can and you can't settle, the court will then look at directions to that last stage. The 3 stages that I talked about, the final hearing is right at the end, and you have to, often you can agree those, but what does the court now need to make a final determination of this? And then it's at that final hearing that's much more in depth, a lot longer hearing. You might have to give evidence at that hearing. That doesn't happen at the dispute resolution hearing.
Okay. And I was asked this question actually the other day. What happens if you can reach agreement in between your failed FDR, your attempt to reach agreement then, and your final hearing? Maybe in some situations, not getting there on the FDR might really focus the attention, or something might change, or your ex-partner might change tack, whatever it might be, and you do reach agreement then before the final hearing. What happens then?
That's fine. And that's actually really, really common, because the purpose of this dispute resolution is to get everyone to focus their minds on what the issues actually are.
Yeah.
What's really going to, what we're really going to be looking at if we can't agree. And then the judge at this hearing is going to give everyone an indication of what a judge might do in these circumstances.
Yeah.
So, but often this can still be, oh, well, I didn't know the judge was going to say that. I need some time to think about that and process that. So it's actually quite common for people to say, I probably just need a few days. I think we're probably almost there, but I want to come away and now think about it. And you would then be in a position where you're doing exactly the same. You're putting your terms into the judge, either by way of heads, actually, because you might be waiting on something else, but more commonly you can then draft the actual detailed order that you want the court to do, and you put it in writing to the judge. Then we do it by way of a process on our court portal, but we say to the judge, look, following that hearing, this is what the parties have now agreed, and it will go off to either that judge or another judge to look at that order and approve it. Hopefully, if it's along lines of what your settlement terms were, within a kind of range, and someone's given something and someone else has said, okay, well, I'll give on this point, and you've managed to settle somewhere in the middle, you can then put that order in. And that could be 2 weeks after your resolution appointment. It could be 2 months if you were waiting on a hearing date. And it could be a day before your contested kind of final hearing is listed. Any point you can agree and put it in. In an ideal world, not only finding kind of for cost reasons and finality, it's better if you can to get that order in straight away, but for various reasons, and perhaps we can explore this in shortly, it's not always possible to do that. People can feel a little bit overwhelmed by information that might not have been known prior to that. Something might come up where they think, oh, well, I didn't know that, and now I don't feel prepared.
Yes, things can take you by surprise sometimes, can't they? And then you might need to go away and talk around it with your advisor, or or with your family or friends and so on. So that's really helpful. I mean, I think when I was talking to this person the other day, there was very definitely a kind of a misunderstanding that once you were in this system, you had to stay in this system, and you couldn't kind of settle outside of this system, if you sort of mean. So actually, you can settle, and you can then put your documents into the court even before your FDR hearing or your final hearing.
You can, and actually the
Very
court's
helpful.
really flexible with
Yeah.
options because of we've done so many other discussions. We've had so many other
Mm,
discussions about this, haven't we? About
yeah.
the non-court dispute resolution. I know we've done
Mm,
one solely on that, and it crops up all the time. So if you say, actually, we've judged, we've taken on board everything that's happened today, discussions, what the judge has said, what the parties have said, and we just got this narrow issue, but we'd quite like to go off to mediation and discuss
mm,
that bit because we think it might be helpful. It might be even house contents or something, we want to go and
yeah.
have a chat about that. You could do that. You could put it off to go off to a separate mediation appointment before you go
Mm,
for that last final hearing. And
yeah.
the court would welcome that,
Mm,
welcome kind of
yeah.
different options that they may well settle.
Yeah.
Obviously, you don't have, an indefinite period because there needs to be a timetable and listing, but it does at least mean that you've got various options to put
Mm,
forward, and mostly they'll be approved by a judge if they're reasonable. If someone says, well, actually within the next couple of months we'd like to see if we can resolve this, and then list it for a hearing after. So you asked me earlier about what you do if you don't reach agreement. You do ask the court then for how long we need for a court hearing. We might say, do we need to put statements in writing so that you've got all that before the hearing, judge? Those are
yeah.
called directions, and within that you may well just you could just reach an agreement, or you can ask the
Mm,
judge, could we have a bit more time to
yeah.
explore our other options? You might need to go back to a financial advisor and get some financial information. So sometimes things do come up, yeah, and it's quite flexible, the process in
Mm,
that sense, for
yeah.
you to be
And I
able to
think
go
that's,
away and file orders at different times.
yes, I think that's really helpful for people to know, that the court system is really flexible, and actually court system wants you to reach agreement. It doesn't want you to have to sit
Exactly.
within its system if you don't need to, and spend all that money and all those costs, emotional costs as well as financial costs to stay in that system. So that's really helpful. Um, I'm going to ask you some of the kind of more practical questions now that I get asked all the time
Okay.
about
Yeah. Fine.
about FDR hearings. So the first one is, where do these hearings take place?
So they're the same as any other family hearing. So they're in what we call chambers of the court. So usually before a district judge, sometimes deputy district judge, who will then do the hearing is in the court building, but actually in quite a small courtroom. It's not
Mm,
intimidating at all. It's quite small, really.
yeah,
In a you'll have a generally one judge there, the parties, and you might have some extra people if people are represented.
mm,
Yeah, so it's within the actual court building, but it's certainly not what you imagine if you're kind of watching television and thinking you're in this big, huge courtroom with various people
yeah,
there. It's not that
yeah.
environment at all.
Okay. And is it possible to go and visit the court in advance so that you can kind of get your bearings, find your way around, work out where the toilets are, work out where where the waiting room
Yeah.
is, all of those things?
Yeah, courts are public buildings. Yeah, no one's asked me that before, but that's a good point, actually. A good question. Yeah, courts are public buildings. You can go in. So our local court where I am here is Exeter, right in the middle of the town centre, just near to the town centre. You can walk in there. Anyone who goes into court, just to bear in mind, this is a practical thing, but you do have to go through a security check. I don't
Yeah,
know if that's one of your questions, Claire,
it is.
but
Yeah.
sorry, I've jumped ahead if it is one of your questions because people often ask that. You do have to go through security. So that's something practical to bear in mind when you go to court. I do tend to try and remind people not to take too much. If you've got, some people might say, their handbag has their half of the house
Mm,
in, don't take that in with you because all the things that you'd imagine going through security have to be removed. If you've got any dangerous objects, or if you've got aerosol cans, perfume bottles, they then have to kind of ticket them in and you have to collect them on the way out. So that's just a practical
mm,
tip to remember
yeah.
that.
And
um
actually an added stress, I think, if
yeah
you're
to
going through
then
security and
oh
several things need to be removed from your bag and you have to get them back later. It's just adding an extra stress on your day. So I think my advice would be to have a separate bag that's ready just with the stuff you need for court in it.
exactly, the important documents that you might want to refer to. Sometimes people like to print things off and see it on
Yeah.
paper. Take a charger if you've got your phone, or you're bringing a laptop because you want to refer to it. You could be there quite a long time. I've had that before where people are saying, oh, I really want to get this, and now my phone's died or my laptop's died because I didn't bring a laptop charger. So the things that you want to refer to in court, yes, but just make sure that you take the minimum amount other than that through. You can take food, you can take drink, it's checked through security as you'd imagine the security. So yes, answering your original question, it's absolutely fine to go and see the courts. You can go into any court building, but you do go through that security check, and that's fine. You can say, I'm just visiting, have a look around the court building. In Exeter and Taunton, I'm thinking both, you'll meet an usher and they'll show you where the family court is. You won't actually go into one of the courtrooms that you have for family, because they have private hearings happening all the time and you don't have access to those. But you can get certainly a feel for the court building, as you say, where the conveniences are, drinks, water machines, have I got to deal with stairs? If you can't use stairs, there'll be lifts, where's the lift going to be? How long is it going to take me to get through security? Is there parking nearby? Normally it's a little walk from the court. So if you can't do that, then you might want to get a lift there, and where can I get dropped off? All those practical things. If you feel that you'd be reassured by doing a dry run, then you certainly could do that before.
I would certainly advise people to do a dry run, and I think it really helps as well with the mental preparation. I often do an exercise with clients around mental preparation. So we kind of run through the scenario from getting up in the morning, getting dressed, getting into the car, getting to the court, parking the car, going through the doors, and you kind of imagine the whole thing, and you imagine yourself behaving exactly as you'd want to, answering questions as you'd want to. There's no problems and so on. So if you've actually been and you can actually visualize the actual place, that makes that a whole lot more powerful in preparation. So another question about preparing in advance that I often hear is, am I going to be able to meet my barrister if I've got a barrister acting for me? Will I be able to meet them in advance? And also, will my solicitor be there as well? And I guess the answer to that will depend.
It will. It will really depend on the circumstances of your case and the finances involved, and whether you want to have a meeting with your barrister before. You can have what's called a conference, which is effectively a meeting with your barrister if you have a barrister instructed. Quite often your own solicitor will do your FDR for you. So 9 times out of 10, I'll be doing FDRs for my clients. So I know all about their case. I've gone all the way through with them. Sometimes the case is more suited for a barrister, or other people prefer to use barristers and instruct barristers from the off. And if that's the case, you probably already have had a conference with your barrister even before your case has got to resolution. So it's really difficult to answer that, because it does depend on A, your solicitor, and B, what the assets and type of issues are in your case. But you can certainly request it if you want it. So some people may well say, I've just been dealing with that this morning, a client who might say, I know it might be added expense to have that extra layer, so to have a meeting before then meeting them on the morning of the hearing, but I want to have that. I need to have that meeting. We can certainly arrange that. That can be done in every case. Or if it's a colleague, so if it's certainly I will do a lot of FDRs at our firm, but someone else might not. So they might refer them to me, in which case I would then meet with I'll have a Teams meeting, or they'll come in and see me. So I would certainly always meet with them before, so they can get a feel for questions that they might want to ask you, and just how you might approach things and how you might discuss things with them.
Yes, very reassuring. And again, it goes to the flexibility, doesn't it? That this is not it's a very flexible process that can be done in a variety of different ways.
And clients have the choice ultimately. So clients have the choice about which barrister they might want to use. We will suggest, if there's, you have to obviously look at availability. So when it comes to your FDR, you would see who's available from which councils, chambers, and say, look, in your particular case, I think these barristers would be suited to what you're looking for. They'd be suited to you. And then the client can always check that. Or it might be, as I say, a solicitor who's worked with you all the way through the case, that they think, well, I know that, X knows all about everything, and I don't have to, remind them of this, that, and the other. I'd like them to deal with it. So it really depends on the type of case it is and what the client wants. But it's certainly an option. That it is very flexible. Yeah, there's certainly various options that you can have.
Yeah. One of the other
Solicitor also be
questions
there. You
of,
did ask me that. Sorry, Claire, to interrupt, but I just thought I didn't
right,
answer that part. Yes, again, it depends on your case. So we wouldn't ordinarily, you wouldn't have, just due to that extra layer of cost, a
mm,
barrister and your own solicitor there. So, you know, if it's a very experienced solicitor, but you may well have a more junior solicitor or a trainee solicitor from the
yeah,
firm who's been running the file as well, you know, very involved in your matter, so knows everything about it, so that they can answer any questions there, that they can guide you through the process when often a barrister's off chatting with the other party or having discussions, and you've got someone from your own firm there to help you. And again, it really depends on the circumstances of the case and what the client wants, but it's all the options are available to that client in those circumstances.
yeah. No, that's really helpful. Thank you. One of the other fears I think that people often have is that they might be called on to say something during the
Yeah, I
hearing.
get asked
So
that a lot. Yeah.
yeah, will I have to say
Say
anything?
anything. Yeah. And
Mm,
I think that's, I would say nearly every client will ask me that. Um, Generally not. So they certainly won't have to give evidence. If you've got a
mm,
solicitor there, you won't have to say anything if you don't really want to. Sometimes an issue might crop up where it's not in the paperwork. So it might be saying, you know, what happened to the car? You know, I know that it was sold. Was that last year? We can't quite see here. You know, the judge might ask a question
mm,
and you can tell your solicitor and your solicitor will speak for you. Sometimes people want to speak. They say, actually, no, I'll answer that. I'm quite happy to. And if they wanted to, of course, they can speak up and answer that question directly. But generally speaking, no, your solicitor or barrister, whomever you've got a court with you, will speak for you. Will communicate, and you don't have to give any evidence at these hearings. They are purely resolution hearings, so you wouldn't have to go on the, I mean, you know, give an oath and give evidence or
yeah.
anything like that. It's not that type of hearing.
Okay. And what does a kind of, if there is such a thing, what does a typical kind of agenda, if you like, look like? What's likely to actually happen in hearing?
Well, they are quite typical. The agendas they really follow the same format throughout. It's just the length of them will depend on the complexity. But the court, when they're listing them, give you an allocated time. So it may well be that you've got, say, for example, they say your resolution appointment is listed for an hour at 11 o'clock. Sometimes they list them 45 minutes, sometimes it might be an hour. But what you'll get told by the court, and hopefully your solicitor, is that you need to allow almost a whole day for that, because although it's listed at that time, the court say you have to attend an hour beforehand to make sure you're there for what's called pre-hearing discussions. So
Mm,
that 11 o'clock becomes a 10 o'clock. So the
yep.
process is you would then turn up at court, or sometimes they're on Teams, but that's quite unusual now. But the court isn't, the preferred option for resolution hearings is to have you in person, because the whole purpose is that you can go to and from, and it's much easier to do directly
Yeah.
in a court building together. You arrive beforehand and you have those pre-hearing discussions. So that's anything which you can tell what's gone back and forth often the few days before a hearing as to how
Mm,
close you are, and is there any more progress that can be made now that we're all here in person. And
yeah.
of course there's a natural pressure that comes to that, you know, because you
Mm,
think, well, actually, if we're all here, we're all spending this money, we want to try and
yeah.
get over the line. So that means that there might be further movement that can be made. So it's those negotiations which you have back and forth. Now, what I know, clients find this quite unusual sometimes, and I have to say, it's probably, I forget to reiterate it to people before hearings because it's just natural to us, we're doing them all the time.
Mm,
But often what can happen is you can turn up for pre-hearing discussions, you'll chat to your barrister or your solicitor. Well, they'll then say, look, I'm going to go off and have discussions, and then that can be quite a lengthy process, and you are not then involved in those discussions. So you're sat in the room that you've got waiting, you know, you're in your meeting room. And sometimes I know that clients can say, oh, you've been gone ages, you know, is everything okay? And they didn't realise that, you know, you're off having discussions with the
yeah.
solicitor on the other side. And so that's
Yeah.
probably something for clients on a practical level to be really aware of, that sometimes you can have your own discussions and there can be big gaps where you're sat
Yeah.
waiting.
Yeah.
So
Yeah.
it
While
can
your
be a bit
solicitor
like,
or your
oh,
barrister is off
yeah,
seeing if they can
talking
find a
about your case.
resolution. Yeah.
And so they're trying to settle it. You know, they're having
Yeah.
discussions because they're saying, look, where can we get, what issues are, how can we narrow down these issues?
Mm,
But sometimes you can think they're going to be gone 2 minutes and it can be 20 minutes. And you get back and they say, oh, I didn't know if everything was all right. And you think, oh, gosh, I probably forgot to say that it can be a little while whilst you're chatting with everyone else. And so you don't then take part in those discussions because the legal representatives are trying to get together and narrow it
Yeah.
down. This is assuming, you both have representatives at the hearing. So yeah, that can definitely be something, I think, where clients think, oh, I wasn't aware of that. I was thinking, how long is this going to be?
Mm. One of the other fears I think that I hear quite often as well is, will I have to, while you're having these discussions, will my ex-partner and I need to be sitting in the same room?
Yeah,
And
okay,
that's a big
yeah.
fear for a lot of people, that they're going to and some people may not have seen their ex-partner for quite, face to face for quite a long time. Um, so yeah, so will I have to see or be in the same room as them?
So no, you don't at all, unless you wanted to. I've
Mm.
had, you know, some cases, and I can think of one that I had earlier in the year, where they were just came to court together and said, are we okay to sit in the room together? And they were quite happy
Mm.
whilst we went off and had discussions. But that's not very common. That's it.
Yeah.
The usual scenario is that you would have your own room. Most court buildings that we have locally here in the southwest, you've got meeting rooms that are available. I can't say that throughout the country because I know court buildings are
Mm.
busier. And not only that, you have limited meeting space, so you might be in a little area of a big room with everyone there. Whereas, fortunately, we generally, I say that generally because you can get really busy court days.
Mm.
There are meeting rooms in our local courts that you can then have your own room. It is important to note that if there has been domestic abuse within your relationship, that you may have extra, what they're called special measures, extra procedures in place. And that would mean you might come earlier, you might have a screen up in your court hearing, you
Yeah.
might have a meeting room that's quite far away from your
Mm.
spouse, about to be former
Yes.
spouse, and that can happen. And they're called special measures. If that's the case, you would have already spoken to your solicitor prior to
Yes.
hearing about that, and the court will be aware, and they make
Mm.
special provision for you so that that is the situation that you definitely don't cross paths. But
Yeah.
assuming it's not that type of situation, then you wouldn't generally have the same rooms. You will see each other as get
Mm.
ready to go into court, but you would be in separate meeting spaces.
Yeah, that's really helpful. And I imagine when you're talking about, well, actually, not even just necessarily a domestic abuse situation, you could always arrange to meet with your solicitor in a cafe around the corner, walk in together,
Yeah.
that kind of thing too, couldn't you?
And that's,
To
yeah,
make it
again,
as comfortable as possible.
complete flexibility. You don't,
Mm.
quite often people do ask that. They might want to, if they haven't already had a conference with their barrister, for example, they might say, can we have a conference in the morning so that it's an extra hour before the hour of pre-hearing
Yeah.
discussions? And that could take place anywhere. That doesn't have to take place at court. It might be somewhere local. It's really common for clients to say to me, can I meet you outside? Can we meet somewhere else? Or can we meet in the car park? What car park are you going to be in? Can we meet
Yeah.
there and walk up to court together? Or, sometimes people feel the support of someone there with them. They can take a friend or a family member to court with them.
Yeah.
That person generally speaking, can't come into the court hearing unless there's special circumstances. But they can be in around the court building with them. They might go and have a cup of coffee with them, or they might sit in the meeting room whilst you're off having discussions. And I think most people find that support, that's quite common as well for someone
Yeah.
to have someone with them.
Yes. Yeah. No, that would be really helpful, I'm sure. Um, and then, as we've already sort of talked a little bit about bringing water, bringing snacks, I know that courts don't always have a cafe or anything like that. So bring some water with you, bring some snacks, maybe bring a sandwich, enough to keep yourself going. The other question, or the other fear, that lots of my clients have is that they'll find it all too much, that there might be a point where the emotions are too much. Is it possible to, what do you do in that situation if you're finding it all just too much right now and maybe you need a couple of minutes or 5 minutes?
Yeah, so you
What happens
will
then?
you will have time. So if it's in this bit of the pre-hearing discussions that a lot of the work goes into that hour
Mm.
before, obviously at that point you can always say to your solicitor, I can't make a decision
Yeah.
right now. Can you just give me 5 minutes? Can you just give me 10 minutes? When the court actually then calls you in, I probably ought to just say what actually happens in that hearing. When you're then called into the hearing, that can last, normally between half an hour and an hour, the court call everyone in once you've had your discussions to basically say, the judge will say, look, where are we? The judge will speak to you. not in any kind of intimidating manner. It's just like, let me know, where are we, what issues are left, have you managed to agree anything? If you have, what has been agreed, what's left to be agreed? If you haven't agreed anything, then let me know. When you come into that hearing, it's less, you can't really have as much time out. But if there was a real specific reason, if you just said, look, I really can't cope with this, the judge would say, okay, let's put it back for a short period. You know, the judge would give you a period of time, but you are still on the court timetable, so there'll be other cases in the list. So you get some kind of freedom to take some time if you really had to, but most of the time you will have to follow that timetable then. And then in the actual hearing itself, I probably ought to just explain the purpose of that then is the judge will then say to you, okay, where are we? Do you need me to give you any assistance with this? That's the kind of phrase they will use. And what that means is, look, the judge will tell you they've read all the papers that you put into the court before the hearing, and that includes everything that is relevant to your case generally. So all your financial information and the questions that you've asked and all the documents that are relevant to your particular circumstances. The judge has that before the hearing, way before the hearing. So the judge will have read all of that. If they haven't, for some reason, they'll let you know. But they generally will say, I've read all the information that you've put in and the positions that you've both put in each from your parties. If you haven't managed to make any progress at all in that hour before, the judge will then go on to say, look, I'm going to give an indication today then of what the court might do if we were looking at this at final hearing. The important part of this is then to realise that at that point, a judge isn't going to, the judge is only giving an indication. They're not saying, I have heard all the evidence, because it can be really frustrating, because what the judge might say is, well, I've agreed I'm assuming that the value of your business is X. There might be different views and different arguments on the actual value, but they will say, I'm using this figure for the purposes of what I'm saying today. So all it is an indication on the papers on what the judge has today in front of them. And they will frequently say, this is not a determination of facts in dispute. I cannot do that today. So sometimes that can feel a bit confusing, that they're giving you this kind of idea of what they think is going to happen or what the judge says should happen, but they haven't really heard everything that I've got to say. You know, I could spend 2 hours telling the judge what the issues are here, and that can be a bit confusing for clients, I think. But the purpose of this resolution is to say, look, let's have a skimmed view of it. Let's have an overall view. Let's just take the figures for what we can see on paper. And I know that this might be in dispute, but I'm going to take a broad brush approach to everything here and say to you, look, if you were at final hearing and I was dealing with it, the judge was dealing with it, I may well say, this is roughly what I think the court would do. It might be within a bracket. It might be, very specific. It might, sometimes they might say, and they'll do that following submissions, so information from your solicitor and the other party's solicitor or barrister. They will hear from them first, only usually for about 5 to 10 minutes, very short, really short. I'll hear what you've got to say and I'll hear what you've got to say, and then I will say what I think the court would do. But they will always caveat it by saying, I'm not dealing with any disputed facts here at all.
Okay.
And if the facts are too disputed, so if they're so disputed that the assets cannot really be ascertained unless a judge makes a decision about them, then sometimes, and this is very unusual, but sometimes the judge will say, we cannot proceed with an FDR today. I cannot give you an indication. You can go and have discussions, but I can't give you an indication. And that can happen, but it's quite rare.
Okay. And then in that kind of case, what would be the next steps on from there? It would depend, I suppose, again on the situation.
It will then, we've had our FDR. We can't have, it's very, very rare, and people ask for it a lot, to not have an FDR. You'll have a litigant in person quite commonly who will say, I know we can't reach an agreement. I want the home to be sold, or, and I know we're not going to reach an agreement. So judge, we don't want this FDR, please. I don't want a resolution appointment. I just want the judge to make a decision for us. I want that person to come and give evidence. And it's really unusual for a court to say, we're going to skip that process, skip the resolution appointment. So there might be cases where you think, I don't think this resolution appointment is going to work, but you still have to have it. And there might be a slim chance that it will work. So in those type of cases, if a judge says, look, I really actually can't give you a firm indication, I can give you a broad idea of what the court might do in respect of the home or the pension. So you'll get some pointers from the
Mm.
judge, but they can't give you kind of finer details. In those cases that you're asking what would happen, it would just then be listed for a hearing, probably sooner than
Yes.
possible, because there's no chance of settlement,
Mm.
because you really need a judge to assist you on certain points within
Mm.
your
And
case.
I that all that makes sense, doesn't it? Given that actually what the court are trying to do is help you reach resolution.
Yeah,
So yeah, they're trying to help you reach resolution, and it's kind of a that sounds like it's kind of last resort. To that you get to that point where you it's really clear nothing can be resolved, and it needs to then go to a hearing further on than that.
and if there
Um,
are facts that are in dispute, I've also had
yeah,
judges give alternatives in that. Say a
right.
judge might do that in these circumstances, but if this might be an
Mm,
expert on, whether someone could
mm,
work, but if the expert said this, then the
yes.
court might do this. But if so, they
Mm,
might give you an indication of saying, this is my indication. But if in fact
yes.
the expert came back and said, wife can't work because of these health reasons, then that indication would change. And I
Mm,
don't think the court would make that
yes.
that would be the outcome.
Yeah.
So you can get alternative
Mm,
versions, if you like, from a judge as well. Again,
yeah.
it really is, the judge is really keen on everyone focusing their minds. The judge will always tell you, we're here to see if we can settle this. We
Mm,
don't, the judge will warn everyone, we don't want to be spending costs, time, and actually
yeah.
energy, emotional energy, having a hearing after today, if there's
Yeah.
a possibility that we can move a bit and see if we can reach
Mm,
agreement.
yes. And bearing that in mind, I was thinking then about preparation and how people can best practically prepare to make sure that they've got all the information that they need to be able to make those decisions, perhaps on that day or in the days following. So, some of this, I suppose, is about making sure that you know your numbers, making sure that you know your sort of top and bottom
Exactly.
limits
Yeah.
on things, and having giving some thought in advance to where you could compromise,
Yeah, exactly.
and where you're willing to bend perhaps, and those kinds of things. Because I think what sometimes gets forgotten, um, is that there isn't just a financial cost to all of this. There's also an emotional cost to it as well, isn't there? It's very stressful going through this process, and so there is a value to working out where you can compromise, working out your top and your bottom kind of levels, and going in with an attitude of wanting to reach that position of certainty.
Yeah, I think that's really important. Reading everything that you've got, you'll get the bundle, but a few days
Mm,
before the hearing, reading all that through, all the paperwork is put into one document, one long document called court bundle,
yeah,
and you'll get it sent by email, and you can click on that. So reading through all of that, and if you do need a paper copy for any reason, that's fine. But yeah, you can read through all that, being prepped, and then exactly that, saying what's my a list of, okay, actually the pension doesn't really bother me as much if it's 45% or 40 or 35%. They're the
mm,
figures that I've been discussing with Natasha, for example, and I'm not worried about that. This is my priority. Usually, certainly with my clients, usually I know you should know already, you should really know what their bottom line is, what that you should have already communicated that
yeah,
through, to your solicitor, and you should have already had that. So you should know what your client wants to focus on and what's important
mm,
to them more,
yeah,
and what they probably would concede. But yes, having that preparation, whether in your own mind or ideally through your legal representatives in advance, to say what you will or won't accept, will help. And something that I think is actually just probably worth exploring and having some ideas from you. This isn't that common, but sometimes I'll be at an FDR and I know that the client is so keen to avoid a final hearing that they're really compromising,
yes,
um, beyond what I would say they ought to compromise on.
yes,
And that is actually really, I'm just thinking about certain cases that I've had, that I've probably been working on one this morning, where you
mm,
have the FDR, and I will say, I really, really think that a judge will never make this order a final hearing. I think you're giving up so much
mm,
because of the fear of this
yes,
we're going to list it for final hearing. It's not, I mean, although it is very costly to go to final hearing, it's normally this, in this situation that I'm talking about, is the emotional
Yeah.
stress of doing it. And I can't possibly give evidence. I can't possibly go through that process. I just can't bear the
Mm.
thought of it. So what you might want to do, and I don't know what you think about this, Claire, and I've never really thought about it in this way, is think, if I think that's going to be the case, I wonder whether I ought to get some emotional support before that, through
Yeah.
counsellor, through divorce support. Do I need to
Absolutely.
actually someone to guide me through how I can be strong enough, if you like, not strong because it's
Mm.
not that you're weak by settling,
Yeah.
but how can I get myself in a position where
Yeah.
I don't go past my bottom line
Mm.
because I feel that I'm able then to take those steps. So getting it before rather than preparing
Absolutely.
after.
Yes, no, I totally agree. So getting that support beforehand so that you're prepared, so that it's pushing through that fear, isn't it? It's pushing through that fear of what the reaction might be, or I'd call it like throwing in the towel, isn't it, really? It's kind of
Yeah.
giving up a bit, and giving away perhaps too much. So I would absolutely agree, get that emotional support in place beforehand. So if you're watching this and you're somebody going through divorce who's feeling like this, get some emotional support in advance. If you're watching this and you're perhaps a fellow professional, refer your clients to emotional support before you get to this point. Um, and we can do lots of things like building up confidence. We can do some visualization work in terms of preparing, um, like I was talking about before, sort of seeing the whole day through and really like building up your strength. We can show you some strategies to help you keep that kind of sense of calm. Breathing strategies. Some of these strategies are really quite simple, but you need to practice them before you need them. So I always say to people, if you feel the emotions rising, take some really deep breaths, but don't beforehand. Every time you boil the kettle, practice your breathing techniques. Every time you, I don't know, when you're making your lunch, practice your breathing techniques so that they are something that you don't have to try and remember in the moment. So practice that in advance. And I know that I don't offer this, but there are people out there who offer sort of more specialist, almost kind of like training in advance of appearing in court. And I know somebody who offers that service who's really good, which I can let you know about that afterwards, who I'm talking about. But yeah, some training to help you specifically with that process would be really good. Um, I think as well, if you have been in a situation with domestic abuse as well, that would be really, really helpful to work with somebody who has specialist experience in that area. Somebody like Karen Kipping, for example, who we've had on talking to us before about domestic abuse situations. Having that emotional support in advance, I think, would be absolutely essential.
Yeah,
Yeah,
because fear of giving evidence
yeah,
is quite a big thing for clients. You know, the idea
yes,
that you might be asked questions on, not
yeah.
because they're telling you to be untruthful, it's just an
Mm.
intimidating process for many, isn't it? I think
Yeah,
for
and
most.
you can get yourself in a muddle, can't you? You know, when you're having to answer questions and there's a fear about being cross-examined and all of those things. So
Yeah.
yeah, really prepare in advance rather than, don't bury your head in the sand and not face that fear, I think is the biggest piece of advice.
And these are really for the clients who, as I say, it really is below the bottom line, because there will be a
Mm.
bottom line where clients will say, I know that I may or may not do better than that, but I
Yeah,
don't want the added stress. I need this to
yeah,
end for various reasons. And that's very different from someone who you can say, I'm 95% sure a judge is not going to order that sale of the home, or
yeah,
we can never be 100% sure on anything, but when it's so obvious, or I don't want to claim against the pension at all because that
mm,
means going to final hearing, and although the judge has told the other party, might be that you will definitely have to share your pension and this is what the court will do, we've come out of that resolution hearing and they're still not agreeing, and you've told me that, so all the
yeah,
judge has said it, you've said it, I still cannot bear the thought of having to be in that environment. It's whether or not you can get emotional support on that to get you through that next step,
yeah, yes,
because sometimes it's obviously up to the client, it's not our decision, and if a client
mm,
says, I know what you've told me but I really don't want to go through that process, um and I'll agree
Yeah,
to what they're asking for that reason. And it's a
yeah,
shame if there is actually steps that you can take to at least try and get over that hurdle that
yeah.
we certainly can't necessarily offer as lawyers.
Yes, no, there's absolutely support out there to help um, get over that hurdle, as you were saying. One of the other things that I actually was talking to somebody recently about this. I was saying go and again get that a bit more financial advice as well. Go and if you're thinking of
Yeah.
throwing in the towel, as it were, at this point, go and talk to a financial planner who can show you what that will look like in 10, 15 years time. Because I've worked with a couple of clients who have done that, and they've come 5 years down the line when life has become very difficult because they were too afraid at the time to kind of push through that. And actually, life can become very difficult afterwards if you end up with a settlement that is way less than it perhaps ought to have been. So
So you're
yeah,
giving
get that
yourself the
financial
best
support up front.
possible chance, really. And the
Yes.
other end of the the other side of that is where your solicitor is telling you that you ought to compromise
Mm.
and you can't bring yourself to compromise at all. and,
Yeah.
and that can happen. It might be you've had a conference with a barrister and they said, look, I agree, this is what
Mm.
you probably need to look at. And you say, I can't, I'm not giving up this for this reason
Yeah.
and I can't budge from that. Um, Again, it's entirely a matter for you, but do you need to think
Mm.
about having options as to
Yeah.
why you're kind of so fixed on that and why you
Yeah.
can't perhaps move
Yeah.
from it?
Yeah. And in some ways, that might be even more from a coaching perspective, that might be actually even more tricky because depending on what's going on for that person, it might be that they're actually not willing to be open to that emotional coaching support. So, I'd have to look at that on an
That'd be
individual basis.
difficult.
Yes, exactly. It
Okay.
would depend what the reasons were behind,
Yeah.
if it, again, because if it came down to fear, I can't give way on this because I'm afraid that this will happen if I do, then that's much more, there's much more we can do with that than somebody who perhaps is very fixed, very rigid, and doesn't want to even look behind it.
Yeah.
Yeah. Um, we haven't got a huge amount of time left.
No,
I
sorry.
wanted I wanted very quickly. There's a couple of things I just wanted to cover off. I know we've talked through the session today about we've made an assumption that everybody's represented, but what if you're represented, but your ex-partner is not, and your ex-partner is appearing as a litigant in person? And I know that that can get very tricky because litigants in person don't always completely understand the system. Um, what advice in the time that we've got left would you give to somebody whose ex is appearing as a litigant in person?
Yeah, that can be really tricky. Sometimes
Mm,
the resolution is really helpful because the litigant in person hasn't had any advice and decided
mm,
against having any advice at all. And actually, a judge in that situation will seize the day and say, look, you're saying that you never want to give any of your pension, I was saying, and it's inevitable that some of that
mm.
pension will have to be shared. So it's good because the judge will give them that
Yes.
outcome there and then and say if there's things that the judge can answer definitively, they will do in that scenario to let them know sooner rather than later. And
Mm,
sometimes it can actually really, really help. You've then done that process. They've been told the situation by the judge. They come away and you reach an agreement quite
mm,
quickly because they've had that information sooner rather than later. There are other situations where it can be difficult because they haven't complied with what they need to comply with. They might turn up to court without having there's certain forms that you have to do, like an ES2 with all the information you've got about your assets. They might not have filed their financial statement. And there is a little bit, some people say, oh, the judge seems to, they give leeway to them because they are litigant in person. Now I've got representation to give them more time to do that. And you might feel that you then are
mm,
in a situation where you haven't been able to make the progress you want. A judge, if the litigant in person just simply isn't doing what they're supposed to be doing, and you come to a resolution appointment and the judge cannot deal with that resolution appointment, the judge would then list it for another resolution appointment if that was the case. And in those circumstances, you ought to get your cost paid, your legal cost paid by the litigant in person. So if they've said, I'm not doing anything, I'll turn up to court, but I'm not doing any of these things that the judge has asked me to do, in that scenario, you could ask for your costs and a judge could say, you've got to pay the cost back. You know,
Mm.
you've totally disregarded everything that we've asked for, and on that basis, we've got to have another hearing of the same nature and
Mm.
exactly the same hearing again on another day. You ought to get your legal costs. So,
Mm.
and the judges will do that, whether someone's a litigant and
Mm.
personal represented.
I
Represented.
suppose and then it becomes about holding your nerve, doesn't it? You know, if you're the
Yeah,
person who's got the
yeah,
representation, we're back to that kind of um, feeling confident enough to hold your ground while you go through that process. I've had a client
absolutely.
go through that very recently, actually, exactly what you've just described. All was well in the end. I suppose it's holding faith in the process, isn't it?
Yeah.
Yeah.
I mean,
Um,
I think I'd say overall, I'd say um, out of the FDRs that we do, the resolution appointments that we do, I would say over 90% settle, either at the time of the hearing or really shortly after. I think they're actually very successful from from a legal advisor's point of view.
yeah.
Um, they tend to focus everyone's minds, tend to make sure that, you know, if there's anything that you haven't quite got your ducks in a row for, you've done it before, everything comes together
Mm.
with some help from the judge on the day as to what the court might do. Sometimes we don't know. Legal advisors saying, you know, we think it should be this, someone else thinks it should be that. And it's really helpful to get an indication from the judge. What's important to know, which I haven't mentioned today, and I think it is quite crucial, is that you are not bound by that indication. And we haven't
Mm.
actually mentioned that. From a legal perspective, a judge, those FDRs are stay within the FDR stay within that court arena, if you like. You
Mm.
walk away from that, and if someone says, "I don't like what the judge said, I don't agree with them," I think a different judge might say something different. At that stage, you can go and have a hearing, your final hearing. The FDR judge, so the resolution judge that's dealt with it, the FDR judge, cannot then deal with the case going forward.
Right.
And it will say in the order that the next hearing will not be by that judge. So that judge will have seen all the negotiations, seen all the offers made. That is all stays with what we call without prejudice. That doesn't go into the final hearing bundle. So that's a really crucial point to make.
Mm.
The idea is that you can turn up at these hearings, speak freely before the judge. The judge can make comments that they might not make if they do hear all the evidence, because it might turn out
Mm.
differently. And you can all have that free discussion, if you like, and that won't be then you won't be bound by that if you go to a final hearing.
Mm.
So if you
Yeah.
really don't like what the judge has said and you think that it's actually doesn't make any sense, and I really do, my advisors are telling me that I think a judge might do something different, you don't have to accept the recommendation. But as I say, I think they're a really good part of the process. I really do. I think
Mm.
that most of the time they
Yeah.
enable the parties to take on board what the judge has said and reach agreement.
Yeah. There's an inherent risk, isn't there, in in what you've just described, in that actually then you are placing everything in the hands of one person to
Yeah.
decide on one day, and you don't know that person, you don't know that person's background, you don't know that person's viewpoint, and you know it leaves it all really quite unpredictable. I think that, you know, actually a really good point to end on is that if you can agree and if you can build your confidence enough up enough to go into these hearings and so on, if you can agree, it's going to be much better than leaving it to one judge on one day at
Yeah.
10 o'clock or 11 o'clock in the morning to make a decision about your future. That
Yeah.
becomes quite unpredictable potentially, doesn't
That's the
it?
main message you'll get from the judge. The main,
Yeah.
you know, a judge will say to you, "Look, this is what I think will happen. You're not
Mm.
bound to agree today, but it's within your
Mm.
ownership. If you go out today,
Yeah. You
you
maintain
both
some
own this. If
agency.
you see,
Yeah.
so one of you makes compromise here. If you make a compromise there, and we can get you somewhere in the middle, then you've both done that together."
Yeah. Fantastic. That feels like a good place
Yeah.
to end. I hope that we have given, I mean, I think we've given a huge amount of information there. And thank you very much, Natasha, for all your expertise over many years in
No, thank you, Claire.
in helping everybody who's listening to understand exactly what an GR is, what it looks like, what its goal is, and so on. We will be back next month on, I think, the 16th of August, when we'll be talking about new relationships and avoiding making the same mistakes again. So we will see people then. And thank you very much for watching. And thank you, Natasha, for your time.
Thank you, and you, Claire.